We are on, and thank you for joining the Cello Law Group Q&A, where today we're going to try to clear up all the confusion that relates to issues like whether to amend, whether to file anew, the new changes that are happening with the H-1B regs, and what we, expect that will turn out to be. So I'm just going to give it a few seconds to make sure everyone, is ready, and then we'll go ahead. So I hope everyone is doing well. What we'll do is it's going to be a very quick presentation. I wanted to leave most of the time for the Q&A, which I think is going to be significant, because that's where the meat of the matter is. And so for those of you who are joining for the first time, welcome. For those of you who have been dedicated participants, thank you so much. Let's start with the webinar. So there are different ways to connect with us, and I'd really like to connect with all of you. We try to get out information relating to the immigration changes in different ways. So sometimes it's through Facebook, where it's a little more detail. Twitter may be, here's something that's coming up, and we're going to let you know what's going on. On YouTube, we have webinars that we've hosted in the past, and we also have information where we talk about different matters that may be important to you, like perm processing. What do you need to know? H-1B, how to respond to RFEs. So if you haven't, please join us on YouTube, so that, subscribe and comment, let your friends know, and we really appreciate that. I'm sorry, I'm so bad at this. There we go. You think I would have gotten better by now. But anyway, so let's go ahead and get started. Like I said, we've got previous webinars. Please take a look at it and let me know your thoughts. And if there's a particular topic you'd like us to cover, we would be happy to do that. Proposed rules in works. The biometrics collection, the expansion. So previously it was only those people that were seeking the benefit. Now they've expanded it to a lot more people, including U.S. citizens and green card holders that will be filing on behalf of their with their beneficiaries. And the interesting thing is, they've also expanded the definition of biometrics, so it can be a lot more than what is currently envisioned as biometrics. That's going to be ripe for a lot of privacy violation rules. So, we'll have to see what takes place. The fixed admission for FJs and I non-immigrants, the U.S. CIS rule on fast tracking the new regs, which, if it's anything like the fee, the new fee rules that they implemented, they did that without going through what's called the Administrative Procedures Act. Every U.S. agency has to go through, when they're trying to change regulations, some processes called notice and comment. There's only very few instances where you can forego that. And I don't believe that a judge would find that imposing these rules without the ability to have notice and comment would be one of them. The prevailing wage rules, we expect that DOL is going to be publishing that as soon as tomorrow as to what the new wages are going to be. As a strategic matter, even though we are pretty sure it's going to be challenged, and there's not really, there's going to be a delay in implementation, and then we may have a new administration. If you have an H-1B that is going to expire within the next 6 months, this may be a good time to go ahead and extend. So as I said, the biometrics rule is, can be palm prints, photographs, facial recognition, and it would dramatically increase the number of collection. It would also increase fees for the USCIS in terms of biometrics. So as I said, anyone associated with the filings whether it's age or U.S. citizens and permanent residents. It really expands the people who would, be classified as that. So, and then fixed admission, as I said, right now for Fs and Js and the like, it's DS. And Congress did that on purpose, because if a person comes in for one, it's DS meaning duration of status. So if a person comes in for one classification, they may get another higher degree. So duration of status, as long as they maintain their status, whether it's F1, J1, they are permitted to stay on that status. The issue came out where the USCIS was trying to impose an unlawful presence element to it. That's been enjoined. So they're trying to get through it through the back door by imposing term limits so they can implement the unlawful presence. So this is going to be litigated as well. Oops. It says it's effective December 7th, and it's foregoing notice and processing. So the new fee structure rule was enjoined nationwide for the very same reason, because it did not comply with the APA. And so I suspect that this is not going to resonate well with any federal judge that is worth their money and has not been placed in the office for other reasons. As we talked about earlier, it narrows the definition of specialty occupation, greater compliance, and would maximize the validity period of third-party placement. So specialty occupation is been deemed to, and this is in, I guess, in retaliation or as a result of the court cases that came out recently where federal district court said, USCIS, you're not applying the definition of specialty occupation correctly when you are denying petitions. And they made also, they made issue as to the requirement that a petition could be denied if there's abundance of evidence that the employer has sufficiency of work, just because he doesn't have one particular contract. The contract ends on a certain date. So a lot of these court cases, they're trying to combat by instituting these rules, which are going to be enjoined. Because for several reasons. Number one, regulation is directly in the purview of Congress. And number two, because you can't fast track something like this that is substantial. You can fast track things that have no impact. That's usually the standard. But for this that would have impact on people's status, I'm pretty sure it's going to be enjoined. So I'm not too worried about it. But like I said, strategically, it's probably a good thing to go ahead and file it, if you have an H-1B that's going to expire. Because you can't file an H-1B extension unless it's within 6 months, because the LCA cannot be certified. You can only be certified 6 months prior to your expiration. So if you have it within the next 6 months, this is a good time to go ahead and get it filed. And so they're trying to make it more stringent, the specialty occupation and the employer-employer relationship, which we have been struggling with for the longest time. So they're trying to get around the federal case with relation to that as well. The regulation is the job cannot be speculative. It has to be anticipated. So if an employer is able to show that they've had jobs, they've been paying the employee, that would mean it's not speculative. Speculative means there is no basis in fact. Whereas anticipated means there is some basis for our assumption that there's work. It's in the regulations, and so that is in the purview of Congress. So this particular new rule would fail on so many measures, a legal challenge. I mean, it would be successful on a legal challenge because of so many things that's problematic with the regulations. And this is just in case you want to read later on. You can come back and look at the YouTube video, and you can see how the USCIS defines employee-employer relationship. So effective immediately is supposed to be the computation of the wage levels, which are going to go up dramatically. And we see that, you know, from what I understand, DOL is supposed to publish this tomorrow. So, I mean, publish more details of that rule soon. Anyway, the wage protection, PWDs pending on or after October 8th. Yeah, October 8th is PWDs filed on after, and LCAs filed on or after October 8th. File an extension early, gather strong evidence, prepare for a new one-year max on third-party placement. Okay, here's our Q&A session. I wanted to go over this because I think, I'm trying to see. Okay, if you can see here, I have outlined what the issues are for amending an I-140 versus a new I-140. Now, the authority that we have for amendments is the 2007 USCIS memo by Newfield. That was at a time in 2007, Chinese nationals, for Chinese citizens, EB3 advanced over EB2. And that was right around the time where PERM just got instituted. So Newfield issued a memo, and the purpose of the memo was to say when a PERM is preserved effectively. Because the regulations state you have to file a PERM within 180 days of certification. If you don't, the PERM dies. The PERM dies if it's not filed within the 180 days of certification. If, however, you file a PERM within 180 days of certification, and you know, then you're able to use it for a number of other things. If the I-140 from that PERM is approved, your priority date is vested with you. It's vested with you, and it cannot be taken away unless your PERM was prepared due to fraud or misrepresentation. Number two, you can continue to get extensions on your H-1B based on that I-140, approved I-140. And if that I-140, as I'll talk about in detail, ever gets denied or something should happen, there's some refiling that you can do with it, because remember, the underlying PERM is preserved. Okay, so that's the premise. So that was a 2007 memo. In the memo, Newfield talks about the way the PERM is preserved, with that being the overarching purpose. And then he states, these instances may occur, may occur. It's not emphatic in saying that there's a difference between a memo that says it will occur in these instances. So because he had the word may, and one of the examples that he gave is if you change classifications and file a new, you know, he goes, you may amend, for example, you know, this may occur when you amend a petition to change classifications. So at that time, we took that language as being an example, not as a fixed, this is the way you can amend. So for years, we had been filing new I-140s pursuant to that memo. And and it worked. Now the problem is we've got a new administration, which has not been very friendly to immigration on a great level. And they're trying to interpret things differently than it's been interpreted for years. So and then the current USCI memo memorialized or formalized that 2007 memo. So it does list those instances, like you can file a new petition if your I-140 has been denied or revoked. You can file a new petition in a successor in interest, whereas really for successor in interest, you would file an amendment. So because it's memorialized, when we are going through this process now, and let's say the Trump administration gets reelected, that's when all this is going to be adjudicated. It's not going to be adjudicated in the next couple of months. It's going to be adjudicated in 2021. So if you've got a Trump administration, and I was special counsel under Ken Cuccinelli, the USCIS director, and I know for a fact that if I say to him, Ken, you've got a current US policy memo that your administration created, because the US policy manual was created by this administration. So there is, in an amendment, I think the risk is de minimis if you meet all the other requirements for a Trump administration. Now, under a new I-140, really within the 203 I-140 regs, it is implied that you can have multiple petitions for one perm. It is also implied in the I-140 instructions. And the Nebraska Service Center, in a Q&A in 2014, which is much later than the 2007, affirmed that you can have multiple petitions for one labor cert. So there is some authority, and there is a way to make an argument. So we don't know who the next administration is going to be. All of this depends on your level of risk. And there are some instances where I would take the risk. Like I said, lawyers, our job is to argue the law. So whether you file an amendment or whether you file a new I-140, I am prepared to argue that there is some basis in the regulations that would allow for that. And that's the authority that I would use, and you should know that. You should also know that the kink in all of this is, the current administration. And if we all could predict who's going to be the next president, then that would be great, but we cannot. So let's look at what would happen if, in the instances of amendment or a new I-140, if it's approved. If the amendment is approved, your EB2 that you're amending or downgrading to EB3 no longer exists, right? You've amended it already. If you're filing a new I-140 and the new I-140 EB3 is approved, your EB2 petition is not effective. You then have an EB2 that you can utilize later on, and you've got the EB3 that's attached to the adjustment of status. If it is denied and you're filing an amendment, the EB2 petition is not effective because you are filing an amendment. So the previous EB2 would be intact. If you're filing a new I-140 and it's denied, you're filing a new I-140 EB3, so it is not effective. How is CSPA treated in these two instances? Now remember, we're filing the adjustment based on dates for filing. That does not protect or lock in CSPA. And I think a lot of people, when I've told them that they can do this, they get confused. But what I was talking about is there is a strategy to protect CSPA in filing the adjustment in October. And how you can do that is if you amend, you don't get a CSPA protection with that. But if you file a new I-140, it's not the adjustment that gives you the CSPA protection, it's the new I-140. So during the time the I-140 is pending, and we're going to have a lot of, right now, the current processing time without this influx is about 7 to 9 months. But you're going to have a great deal of filings in the month of October, so that could increase the processing time. If there is an RFE, that could increase the processing time. The entire time this petition is pending would be added to the age out child, right? And so, you know, that is what you are gaining in filing the new petition that's not available for the amendment. What are the risks? So if it's denied, the risks for when you amend is sorry, if it's denied, if the EB3 amendment is denied, remember your EB2 is intact. So you would have to refile when the priority date is current. You forego the I-140 and I-45 fees, but you do have the ability to refile. So I know those fees are expensive and it's a lot, but it doesn't mean that it's the end of your immigration journey. If you file an if you file a new I-140, again, you refile when the PD is current and you forego the fees if it's denied. Now, what happens to retrogression? With retrogression, you can, if you filed an amendment from EB2 to EB3, you can file a new amendment from EB3 to EB2 with the pending, with the I-140 that you were trying to convert. There is no limit on how many amendments you can file, so you are permitted to do that. It may cause a delay. The other thing you can do is during this process, because it's going to take some time, you can go ahead and get started with a new perm and get an I-140 approved under EB2 that you can, instead of amending, that you can interfile. So that's an option. Now, if you filed an an I-140 for a new petition, and whether it's pending or whether it's been approved and there's a retrogression in EB3, you can interfile your EB2 approved I-140 if the priority date, and for both of these and for anything, if the priority date is current. So you'd be able to interfile. So these are the risks and strategies and thoughts for the processing. So this was last week's agenda. So if you haven't, if you weren't able to join last week, our webinar, these are the things that, and I go into all of this in greater detail, including CSPA. So you may want to take a look at that, go to our YouTube channel and subscribe to the Cello Law Group YouTube. And here are the final date bulletins and some of the things that I had gone over. So, as you can see, it is pretty detailed with regard to what we go over. Incorrect birth certificate, or you obtained a birth certificate many years after your date of birth, what you need to do in order to overcome that. We have a sample of the affidavit of birth, a sample of the certificate of unavailability that you would be able to use. And some additional reminders. So if you were not following us on our Telegram group, please join. I'm on that quite a bit, and I try to go through. It's the it's not very user friendly. So the problem is I go up, I'll answer a question, it takes me all the way back down. And but I do try to, every evening I spend a few hours on it, trying to answer questions directly. We're even updating it with kind of, information on handy tips. So yesterday I uploaded something on ability to pay, which if you're filing a new I-140, everybody should know what, the issues related to ability to pay. So take this link and join our Telegram group so you can be part of the conversation and get your questions answered immediately. As I said, there are many ways to connect with us, And if you want to look at last week's very useful YouTube video, you can do that on our YouTube channel. And if you have any questions, you can email us at info@cellolaw.com. So that is info, you see it right there, INFO, @cellolaw.com. So I'm going to start taking questions now.
You want me to read the questions?
Do you want to first start getting people to, I'm trying to stop screen sharing. Let's see, I'm trying to stop screen sharing and trying to figure out how to do that. Oh, for some reason, it's not letting me unshare. So if somebody has that way in which we can stop the screen sharing, that would be great.
I don't have
Because usually it lets me just stop screen sharing immediately, but I don't know how to.
no, hang on, let me just sign in.
Now, if you've got questions, I would request that you put that on the Q&A versus and if Kara, you know how to get me out of screen sharing, I would really appreciate it. I'm trying to, usually it gives me an option.
Okay, I'm trying, I just joined in, so let me see. Screen sharing,
It usually lets me stop screen sharing, but it's not.
well, it says here host disabled.
Okay, there we go. I got it.
Okay. You want to start then?
Yep.
All right. Good afternoon, everybody. This is Shekhar Challa. So I'm going to take the questions from the top. And I think if I don't see questions that were sent before, I think my first question I see is at 12:35, unfortunately. But if there is a question that you sent before 12:35, please send it again. Apologize for all these technical difficulties. We'll try to do better next time.
Well, let me get the first few questions, and then that way they don't have to rewrite it.
Okay.
And then you can go ahead. Hey, good afternoon, Abir. I'm so glad that you're here today. I hope everything is doing well. I was just thinking of you and your wife yesterday. $1 million question, new I-140 with amendment or brand new without mention of the previous? No, there's a way in which, okay, the question is when you're filing, whether you're filing an amendment or whether you're filing a new I-140, can you do that without mention of the previous? No, because you don't have the original labor cert. So I cannot underscore the importance of filling out that I-140 correctly. Make sure your attorney knows how to do that. That is the #1 reason for denials of I-140s when there is a downgrade. it is because the attorney didn't check or didn't do the right things that are needed for the I-140 downgrade. So you have to specifically mention that the USCIS needs to obtain the perm in the previous petition, and they have to request it if it's not on site with the DOL. Next question, could you please elaborate on how to get back to the EB2 line later after the after the EB2 has been amended and the I-140 has been filed concurrently? Do we need to amend back? Yes, I had answered that during the initial dialogue that you have the ability to amend the EB3 back to EB2. It may cause a delay, or you can file a perm with a new EB2 in the interim. Those are the two things you can do if you're choosing to amend. As we need to have parents' passport details as the I-40. Unfortunately, there's a difference in the birth dates of my mother on her passport and when we filed the DS 5 years ago. So someone is asking, there's a discrepancy on the passport details of date of birth of their parents from when they filed when she filed for the B2 visitor visa coming into the United States. I would put in an affidavit and I would explain the discrepancy, and you want that in record because down the road, if you're going to if you're going to sponsor your parents, that would be helpful to explain it now. I'm on 1213 high. I've got an EB2 with a current employer. What is the recommendation to downgrade to EB3, amendment or new? If it is a new filing, is it legal to have multiple filings? So we address that. Hari, if there's something that you didn't understand in what about, the question the table that I put forth that explained the differences, ask another question in relation to that. What about the major companies? What are they filing a new or amendment? And they're doing a mix. And so here's a question at 1218 that was sent to me by email. My husband's H-1B visa is filed on August 15th. We're waiting for the result. Is it better to change premium now to make sure the decision comes into effect? No, because you filed. Okay, the question is because of the new H-1B regulations, someone has a pending H-1B and they want to know if they should, upgrade it to premium because of the new proposed H-1B changes, and pending H-1Bs would not be affected by that, so it is not necessary. Can we have two I-145s? Yes, and I've talked to this where a husband and wife may have an I-140 each, and so they may choose one to file in October by downgrading, and later on, if the EB2 advances, they can leverage the other EB2 and have another I-485 pending. So there is nothing in the regulations to bar that. Has the EB1 become premium processing based on the recent article, or is it still in process? Do any of these changes for H-1B apply to the L petition? Okay, so the fee structure, the premium processing leveraging, I think they're still trying to work through the mechanics of that, because remember, that happened on the night the president got COVID. The regulation was passed, but I think everyone is in an influx right now. So it should be permitted, but they have to put the infrastructure in place. How would the new H-1B interim regulation passed yesterday would affect existing H-1B approved or those working at third-party work sites? Not existing, only those that are going to be filed anew. And for the person that asked about the multinational premium processing, they also asked if the new H-1B regulations would affect Ls, and it would be not. It does not. So I think this is the last one before 1230. If I go to India for my H-1B Dropbox visa, will I get a 221G at present for the embassy? Does the embassy accept this kind of cases on a walk-in demand right now? If you had an approved H-1B visa within the past 24 months, then you are eligible for Dropbox if you meet all the other criteria. And we had posted the Dropbox criteria, I think it was last week or maybe the webinar the week before, but you can check that out if you've got any questions. It is on our YouTube webinars. Shaker.
All right. So I see quite a few of you have posted a question which says anonymous attendee. That's fine. But, it'd be nice to have a name associated with it. That's okay. So the first question is on, this question is about AOS related. My priority date in EB2 is current with EB3. My employer agreed to downgrade my petition to EB3 and file I-485 concurrently with I-140. What are my options when it comes to changing the employer after filing? Can I change after 180 days of filing the I-145, 485, or should I also wait for 6 months after the I-140 approval happens, as in the case of a new I-140 petition?
Well, no, what your analysis is correct. Your application is incorrect. So you're talking about AC-21, portability of green cards. In order to avail yourself of AC-21 portability of green cards, right, is that you can, once the adjustment has been filed and the I-140, and you don't want to go through that process again with a new employer, you can port to same or similar employment as long as two things occur. The I-140 is approved and the 485 has been pending for 180 days. Another interesting fact that you should know, that anytime you interfile, right, you can interfile, that 180 days gets triggered again. So that's something to keep in mind.
Okay. The next one is coming from another anonymous attendee. What are the timelines for document submissions? Are there any new forms which are updated, and which forms are to be used?
Right. Okay. So there is the I-944. So after October 14th, if your adjustment does not include an I-944, it will be rejected. They won't issue an RFE. It will be rejected. So if you want details on the new forms that have been updated, I know that the forms that were proposed to be updated along with the fee increase are on hold. But there are certain forms that have been updated within the past few months, and we can send you, I think we have a memo on that. So email us at info@cellolaw.com if you need information on that.
All right, next one is from Sandeep Kaur. Sandeep Kaur, where are you from? Where are you?
You'd have to ask them to unmute.
Oh, unmute. Oh, sorry. Just to get the, conversation a little bit interesting,
Right.
Sandeep Kaur, I guess I can do it too, I guess.
You should be able to. If you can't, I will. Because there's a lot of people that have raised their hands.
Yeah. No, there's no hand raised, but anyway, don't worry about it. There's so many questions. I just wanted to.
You want me to allow Sandeep to talk?
That's okay. If you got there, yeah, you can have her talk.
Okay. Sandeep.
Hey, Lakshmi. Hey, Shekhar.
Hi.
How are you guys doing? Thank you for doing the webinar. It's really great. I enjoy your webinar.
Good, good.
So let me answer where are you from, Sandeep? Where are you calling in?
Right now, I'm actually stuck in India. I'm waiting on my stamping. And my priority date is January 2011, EB2. So I qualify for the adjustment. But first I need to get my stamping approved.
Yes, so, you need to get to the US.
Yes, back home in New York.
So I'm going to read your question, especially, your question says, especially the wage increase that affects from tomorrow. How would that impact the existing approved H-1B petition, those are working at third party?
Right. So they can't, US law cannot penalize or cannot impact benefits that were already issued. So it would only impact any new petitions that are going to be filed. But if you come back to the United States and you have to file a change of employer,
Mhm.
It's not going to impact your visa stamping, but it may impact your change of employer.
Okay,
All right.
sure. Thank you. Thank you
Thank
so
you,
much.
Sandeep. So I'll go to the next question. Neetu Mohanika. And in the interest of time, because there's so many questions, I think we'll just answer the questions.
Right, because we have about 46 questions right now.
Yeah, her question is, ability to pay will come after perm certified date or filing date?
The ability to pay, and if you have not joined our Telegram group, I would encourage you to do that, because yesterday I posted a memorandum that kind of talks about how you can prove ability to pay. Ability to pay, per the regulations, say it is from the date the labor certification determination, the day it's certified, through the green card is what the regulations state. But practically speaking, it means at least from the labor cert till the time you're filing the I-140, because that's when it's being adjudicated. So, and they can show that in many ways. So join our Telegram group so you can, you know, avail yourself of all those resources. That's the only place that we're placing them. And I got to figure out how to put them in a file so people can access it. But if you look at things that are shared, you should be able to find that. And it clearly says the 3 ways the USCIS adjudicates I-140 ability to pay.
All right, so let's go to Rajiv R. Can I file I-485 next month when my PD becomes current next month with my ex-employer and file supplement J with current employer after 6 months?
Now,
Can I file I-485 next
do
month?
you mean this month? Because we don't know yet what next month's priority dates are. So I would imagine that you're saying this month. So yes, you can file. Permanent residence is for prospective employment. That means future, when the green card is approved. One thing that you have to do is show that you have a bona fide intent to file. You are attesting under penalty of perjury that you do intend to work for this employer, which means that doesn't mean that you can't change your mind later on. That's why we have the portability of green cards. But while filing it, you must at least have that intent to work for that employer. So I have stated previously, shaker, you shake, oh, there you go, you're steady now, you were shaking. I stated previously that you should have that in writing, that you do intend to join them after your green card is approved. That should be your intent right now, and you should have some proof if somebody challenges you down the road. Now, from a practical perspective, once the I-140 is approved and the 485 has been pending for 180 days, you can, yes, port and change employers using supplement J.
All right, let's go to Rajiv R. Raj R. My 140 with the previous employer, EB2, has been withdrawn. Can I now file for a 140 in EB3 through premium processing and parallelly file for EAD? Also, is it advisable if I am not on my previous employer's payroll?
Okay, so yes, you can file with a previous employer, even if it's been revoked or withdrawn rather, because the perm is still valid. You have to file a new petition, but the perm is still valid. And what's great for you is that you will be able to file a new petition under EB3, but that means you wouldn't have a previous, another petition to rely on. So you can file under EB3 doing concurrent filing. That concurrent filing, the adjustment of status gives you your EAD. That's what gives you your EAD. You're not filing for an EAD. The EAD is a benefit that you get with your adjustment of status filing. Okay, next question is, I'm not currently working for that employer, is that going to be a problem? Anytime you file an I-140, you have to demonstrate ability to pay. If you haven't joined our Telegram group, do that. I just posted a memo on ability to pay, which is very critical on that, and it goes through it very much in detail. The difference between proving ability to pay for an employer that you are currently not working for, like a previous employer, is that one of the ways to demonstrate ability to pay is if the employer has been paying your salary. If they have been paying your salary, that the memo that is now formalized in the USCIS policy manual states that the adjudicator should give a positive determination that the employer has ability to pay if the employer has been paying the salary. In a previous employer, you're not going to have that. You're not currently being paid that employer. So the two other ways the employer can show ability to pay from the date of the labor cert to the time you file this new I-140 is looking at the net income on their tax returns for each of those years. For each of those years. Or looking at the net current assets. They can prove it by either net income or net current assets. And the amount of the net current income has to be either equal to or above the salary that's stated on your labor certification. And like I said, from the date of the determination, so if the determination was 2 years ago or 3 years ago, it would be each year from the date it was certified till the time you file the I-140 next month.
Okay.
Join us on Telegram so you can get that memo and you can show it to your employer.
The next question is from Hukesh. After filing AOS, can we replace the perm with new one at later stages, assuming complications could arrive with the old perm?
Absolutely. There's nothing prohibiting, there are many roads that lead to Rome or the green card. So there's nothing prohibiting filing another I-140 485 at a later date if you feel like at some point this particular filing is precarious.
The next one is an anonymous attendee. Could you please elaborate on how to get back to the EB2 line later after the EB2 140 has been amended to EB3 and the 485 has been filed concurrently with the EB3 I-140? Do we need to amend the I-140 back to EB2?
Right. And in my chart, so take a look at that again, and I had answered this question earlier, that when you amend from EB2 to EB3, instead of filing a new EB2 petition, when you amend, there is nothing in the regulations that state that you cannot amend back. So you can amend back from EB3 to EB2 once the priority date is current. Another thing you can do in the abundance of caution is go ahead and start a new perm process for EB2 at this time. So instead of amending, you would be able to just interfile your new I-140 approval notice when the numbers for EB2 advance.
Okay. Next one is Sheshu. He said, his question, can we have two I-485 for the same applicant, one where he is primary applicant and one where he is a derivative applicant?
I guess what you're asking is, can you have two I-485s, two I-140 485s, where in one I-140 485, you are the primary, and maybe your spouse and children are derivative, and you have another I-140 485 where your spouse is primary and you and your children are derivative? And the answer is yes.
Okay. Another anonymous question. My employer is asking to join him for signing I-485J. Is that mandatory?
No. Remember, when you do a concurrent filing, per the instructions, I-485J is not required. So even if you don't have it for the adjustment application, it is okay. Now, if you are trying to leverage a I-140 from your previous employer, and the previous employer wants you to join them, that's not mandatory. But I suspect that a lot of employers want you to join because of, they want to get something out of it. So they want you to come back and work for them. But there's nothing in the regulations that require that.
Okay.
They may, if the new fees, if the new wage levels come up, what can be a great thing for all of you who are trying to leverage the I-140 from your previous employer is that they may not want to do that now because of the new fee requirements. So,
All right, next question.
wage requirements, I'm sorry.
Another anonymous attendee. If I go to India for my H-1B Dropbox visa, and if I get a 221G to be present at the embassy, does embassy accept this kind of cases walk-in on demand right now? Or will I be stuck there until they resume normal processing?
I think this guy just wrote the question again. That's one of the questions I answered at the beginning.
All right.
Dropbox, look at our.
Go to Ravi Shan. Good afternoon, Lakshmi. What happens during this process of amendment, downgrade EB3 and 485 processing at USCIS? If EB2 becomes current on chart 1, what is the process of applying in EB2?
Right, it depends on how you downgrade. If you downgrade through an amendment, you'd have to amend back. If you downgrade by filing a new I-140, you would just interfile and let the USCIS know you have an approved EB2.
All right, next one is Srini. Hi, I was in senior systems engineer when my perm was filed, and now I'm principal cybersecurity analyst title, and my attorney is mentioning a new perm needs to be filed as this title is significant change in job role. But my current job role still includes the job that was filed in perm. Do I need to still file for a new perm?
It's the duties that dictate it, and the DOL job titles are very limited. So, I'd have to look at the duties, your previous duties and your current duties to make the assessment. You can email us at info@cellolaw.com. By God's grace, I'm knocking on wood right now. We've got a tremendous success rate with our perms. John loves perms, and it's very evident by the way he works on them. When I was trying to do some restructuring, he goes, I don't want you to take the perms away. I really like working on them. And that's why I think he's so successful in the way he does the perms. So send your job description and your previous perm description to us, and we can let you know whether that is necessary. info@cellolaw.com.
All right. Next question is from Jigar, and the question is, what should be there in an affidavit?
Okay, Jigger, if you look at our previous webinar, go to YouTube channel, and today is the 7th, so it would have been 1 week ago. The 1st, is the 1st? 30th. So on the 30th, go to September 30th and take a look at, I have an example in there for you that you can copy and paste. And make sure to subscribe and say that was a great help.
Yeah, please show your love.
Now, there's a number of people that have raised their hands.
Yeah.
Do you want to try to get to any of them?
I'm taking the questions as they're listed. Some of them I see they've raised their hands who already have a question.
Okay.
The next one is Vaishnavi. I have an H1 approved, no visa stamp. Wife is on H4 pending application, no visa stamp, obviously. We are downgrading from EB2 to EB3 and applying for concurrent 485. Our question is, what are travel restrictions? Is it advisable, knowing the risk of embassies closed and we need to be in India till we get the visa stamp?
Right.
Is there a risk to our I-485 or EB3 140 application if we leave the country?
Right. So the H1B and L are dual intent. So you can intend to stay here temporarily or tend to stay here permanently. So there's no abandonment of your I-485 by departing the country. That's issue number one. Issue number two is you do need to have an ability to return to the United States, right? You need to have some sort of entry document. You can either do that through your AP. You can use an AP to travel, to re-enter, as long as you don't use the EAD to work for any other employer but your H-1B employer, you are fine. You can also get your H-1B and H-4 visa stamped when you are abroad. So that is a separate issue from whether your I-45 gets affected by the mere departure. If you were here on an F-1 and you left the United States, yes, your I-45 would be deemed abandoned, but it is not deemed abandoned for an L or an H.
The next question from an anonymous. Can you please elaborate more on the new regulation in regards to the H-1B specialty occupation? What is new?
Right. We will probably go over that in greater detail next week because it is not, I want to wait and see if there is going to be some issues relating to trying to stop or preclude that and some more greater details. But we have, in previous webinars, we've gone over, we just looked, I think it was 2 weeks before. So the 30th of September was the last, I think it's a week before that we had discussed what the proposed regs are and the specialty occupation in particular and how that would be impacted. So I would reserve that for next week. I want to get to all the adjustment and I-140 questions today.
All right, Jayesh is asking, do we need to submit credit report and score for spouse too? My wife has social security number and credit karma shows details, but the 3 agencies do not. Can I use credit karma information?
Email us your question because we have a memo that will help you kind of navigate through the I-944 and what documents and what you would need for that. It's easier for me to send you that than list it right now.
Wamshi is asking, my current status of I-797 is approved till August 22, and my last stamped visa expired on August 2019. I'm planning to travel to India December 2019. Are there any issues or recommendations that I need to be aware of for my visa extensions and return travel?
Well, Dropbox, if you meet all the Dropbox requirements, one of the things they did during COVID is typically you're only eligible for Dropbox if your visa expired within the last 12 months. Now they've expanded it so it's past 24 months. So that is, but you have to meet all the other requirements of Dropbox. But if you do, we haven't seen that there has been much problems with that.
Next question is from Neetu. We had a question from her earlier. Hi, ma'am. I have a question regarding Profit University. Does Profit University come under EB2 category? Ability to pay will come after PERM certified date or filing date? I think we answered that one. But Profit University?
I don't understand. She works for a for-profit university. That's what I'm going to assume. And if you're filing when you're filing the I-140 is when the issue of ability to pay comes up. You don't have to demonstrate ability to pay at the time of the PERM. But when you're filing the I-140 and you have to demonstrate ability to pay, you have to demonstrate ability to pay from the date of determination to the date you're filing the I-140. If it is a for-profit academic institution, they may not have the traditional tax returns. They would have a budget that they would, and they should, they would have a budget. Number two, if you're currently working for them and you're being paid the salary that's listed on the labor certification, that's another way in which you can prove ability to pay. So join the Telegram group, the Cello Law Telegram group, and you would, we've got a document on there that talks about ability to pay.
All right, Parveen is asking, hi Lakshmi Garu, birth certificate was issued from my village panchayat in black and white copy. Will it be accepted by USCIS?
Yes, as long as you have to have the original for the interview. So when you're filing the 485, the 485 filing can be filed with copies of your affidavits, of your birth certificates, of your certificate of unavailability. But if and when you should have an interview, they would ask for originals.
All right, Ravi is asking, my employer is not doing EB2, EB3, and he's worrying about auditing. I'm not sure why he's worrying.
Yeah, he may be worried about if he's got a lot of employees that are doing this, he may be saying auditing, but it's not auditing. He's worried about an RFE in which they question all the I-140s that are currently pending. We also represent a lot of staffing companies. We have seen that very rarely, I think, in 2 instances that I can recollect, and it's because we reference the USCIS memo and their USCIS policy manual that states that the adjudicator should give a positive determination if these things acquire. Now, since you're not being paid by that previous employer, it may be that he's worried about not being able to demonstrate ability to pay based on his tax return. But there's no such thing as audit.
Next question, anonymous attendee. In case of future retrogression after we downgrade with amended petition, once we amend the EB3 back to EB2, do we need to file another 485 based on the newly amended EB2?
No.
All right. Next anonymous question, is the I-140 amendment process same as filing a new I-140 with respect to the form used and filing fee, etc.?
Yeah, and I've been saying this over and over again. Like I said, when we anticipated the numbers would be current, I went and I swept all the denial cases and I tried to look through to see, to identify any patterns by the USCIS. Not denials we've had. We haven't had any denials, but denials by other attorneys. And one of the things that I had noticed for a vast majority of them is they didn't complete the I-140 correctly. There's a different way to complete it if it's a new petition. There's a different way to complete it if it's an amended. And for both of them, there's certain things that you have to request that's common. And so it depends on what your attorney is doing, but just make sure, like I said, that they know how to fill it out and they fill it out correctly.
All right, next question from an anonymous attendee. If I downgrade from EB2, priority date 2012, to EB3 by filing a new I-140, my priority date will be new EB3 I-140 date or original EB2 priority date? Will it be tied to the new EB3 140?
Yeah, when you have an approved I-140 petition, the priority date vests with you. It sticks with you no matter how many other petitions you file, no matter if you downgrade, upgrade, no matter what you do. But you're now filing as an EB3. So the reason you're able to file as an EB3 is you're taking your I-140 EB2 priority date, which is not eligible for the dates of filing, and you're filing it under an EB3. So it becomes an EB3 priority date. And that's why if EB2 advances, you would have to amend back to an EB2.
All right, Samuel is asking, so even if we are not filing 485 for family using the final action date, are we still eligible for CSPA?
No. Your child's, the only way you're eligible for CSPA is not because of the dates of filing, not the adjustment. You're eligible for CSPA if you are filing a new petition, a new I-140 in the month of October concurrently with your adjustment. And the derivative has to be filed in that in order for the CSPA to kick in. And the CSPA will kick in not based on the 485, but based on the I-140 and the duration that the I-140 is pending, assuming that your child is under the age of 21 at the date of filing.
All right, next question is from Shri D. if the sponsored employer withdraw the I-485 petition after 180 days and before the I-140 EB3 downgrade approval date, can I still retain the 485 with new employer by submitting the supplement J form?
You can, as long as the I-140 is approved and it's been pending for 180 days.
All right, Mr. Jigger is back. He says this is a beneficiary dependent mother's name. Mother's name in birth certificate is spelled differently than in passport. What should be there in birth affidavit? Should it match the name per passport?
Well, whichever is the correct. I mean, I think we talked about this. You're going to have to get that addressed in some way. Why is the passport office, why did they issue the incorrect name? I've seen it sometimes where a name can be spelled differently, and the passport office just makes a mistake. Like my name is spelled Lakshmi, but it also can be spelled Laxmi. So is that the reason for the difference? Is it because they superimpose two letters? You have to at least identify why they made the mistake. And what I would say is in the affidavit, you go by the name in the birth certificate, and in parentheses, you say also known as, and you have the name as outlined in the passport and have it prepared that way.
All right, Manish Agarwal is asking if we have minor traffic citations, do we answer yes for form 485, page 11, part 8, question 25? Have you ever been arrested, cited, charged, or detained for any reason by any law enforcement official?
Right. So a citation, a traffic ticket is a citation. So I would just say yes, and in the addendum, just say it was a simple traffic offense. So you will answer yes, and I would put copies of those tickets because as long as it's not a DUI and it was just a speeding ticket or a parking violation, you were cited. A ticket is a citation. So you would answer yes and put the evidence in and explain it was just a simple, and it's not going to impact you, but you have to answer it yes.
All right, Sriram is asking the interim rule put forward for H-1B is temporary or permanent, and when it is effective?
Well, there are two parts of it. So there's the fee part, the wage part, and then there's the rule with specialty occupation and third-party placement restrictions and everything else that's effective December. It all depends on who's elected to the next president. That's what this is. If it's number one, it's going to be challenged, and it is the challenge. They will issue a nationwide injunction because the USCIS did not follow the APA. So I don't think it's even going to be applicable now. The other thing is if we have a new administration, one of the first things that President Biden is going to do is an overhaul with immigration reform.
Next question from an anonymous. What can we expect for the future of H-1B and PERM prevailing wage requirements for next year?
As soon as I think we've posted some of the changes that we've seen right now. But for next year, you can't predict because remember, it all depends on the election. It all depends on these court challenges that are going to come up. So what we have to deal with, at least in this administration and in election year, is what's going to happen this month. And that's why I didn't want to talk about the H-1B in too much detail, because I think between now and next week, we will have better direction.
All right, Shri is back. Can I withdraw my I-485 myself, or only employer can withdraw the I-485 AOAS?
You can withdraw it.
All right. Shafeen Tawheed asking, what are the next steps after filing I-485 EAD and AP?
Well, you're not filing the I-45 EAD AP. Let's be clear on what we're filing, because this is your immigration process. You're filing the I-140 and 485. A benefit of the 485 is EAD and AP. And the next steps will be, they will remember it's filed for dates of filing. So the I-140, if you're downgrading, will be adjudicated. It's not dependent on the priority dates. The adjustment of status, they'll do the initial intake, issue AP and EAD, which is taking anywhere from 4 to 5 months. I think it's going to take longer because of the number of people that are filing. There'll be biometrics, but that's where it stops. So they won't adjudicate the adjustment of status until the dates are current.
All right, Mr. Abir is back. Hello, Abir. He's asking, do we expect that they will allow EB1C to be upgraded if the bill is not completed by the time John M. will file my I-140? Next question, do we expect the EB1C to be current by December? I believe your bulletin says 1st September 2020.
Right. We suspect, I think that's one area where, because right now the large number of filings are going to be into the EB3 category. And so because they're allocated per country, per EB1, EB2, EB3, based on filing, I think we do suspect that it will become current within the next month. And once we file, whenever you file a petition under regular processing, it can always be upgraded to premium at a later date.
Okay. Let's go to Krishna. My name is Krishna. I have a current H-1B visa stamped till July 2021. My 140 submitted on April 24, 2020, still in progress and waiting for approval. Do you suggest to apply in premium processing? Once my I-140 is approved, my company's attorney will file for H-1B extension. Please suggest if anything I need to consider for my I-140 approval and H-1B extension.
Okay, and can you give me the priority date of the I-45?
485.
Sorry, I-140.
Submitted on April 20th. I have a current H-1B visa stamp July 2021. 140 submitted on April 2020.
Oh, okay.
Still in progress.
Yeah, you can file, you can get that upgraded. Remember, it's 15 business days now, not 15 days. And then you would, once the I-140 is approved, you're able to get your 3-year extension. I mean, you can wait and see, but if you just want it, remember, it's not your visa that dictates when you need to get an extension. It's your I-94 card. So, and you have to have, your expiration has to be within 6 months, 6 months or less in order to file an extension. So I would, if it's 6 months or less, and you are up on your 6th year, then yes, I would go ahead and file premium so you can get an extension.
The next question involves a lot of mathematics. So the anonymous attendee says, current prevailing wages use the formula below. Level 1, 17%, level 2, 34, 3, 50, 4, 67. The new rule changes the formula level 1 to 45, 2 to 62, 3 to 78, 4 to 95. Can you please provide some more information on the percentile increase calculation of wages? What does it mean for the employers?
Right, if you're not filing a new petition right now, then it doesn't mean anything for you. And I think one of our slides addressed that today, and that's what we will be covering in detail next week. So join us next week. And
I think his follow-up question on that, I think it's him because it says anonymous. Can we interfile after we use AC21? Maybe it's not him, it's somebody else. I don't know.
Okay, they're two different things. AC21 is the ability to change employers after filing an I-140 485 without having to refile them again. You can do that when the I-140 is approved and the 485 has been pending for 180 days. Okay. If you want to change employers after that, then what you would do is you file the J, right? The Form J that says, here I am, I'm changing employers. If it's still pending, your I-140 and 45, and the I-140 has not been approved, and EB2 advances and you file the downgrade, that's when you would interfile.
Next question is not a question, it's an appreciation from Sandeep Kaur. Says, Lakshmi and team, thank you so much for answering questions so patiently. Also helping me to get EA for visa stamping. Your
Let's
help is much
fingers crossed, Sandeep. We want to get you back into the country.
I know, Sandeep, you have raised your hand, but I'd like to, go to the other questions. Just to have some little patience, please. Aman is asking, in reference to the new H-1B change yesterday about having relevant educational qualifications, will it help if one does such a course in the United States? I'm a master's from India. Should it be a master's course?
Yeah, I would defer all the H-1B questions to next week so we can get to as many as the I-140, 45 questions.
Pushpak Narayan is asking, I am with the same employer since 2012. My priority date is August 2014 in EB2. We are planning to apply for a new 140 in EB3, requesting to use the old perm approval. They're also filing 485 plus EAD plus AP. Do we need to file 485J application as well?
Okay, so first, if you don't have an age out, why don't you just amend, since you've been with the employer for so long? That would be my one question to you. Number two, you don't have to file the J when you're doing a concurrent filing, but they may ask for the J at a later date.
All right. Lakshmi Hitali is asking, what if the name of the city is changed now? My passport has the old name of the city. I'm from Karnataka. Name of the city is changed.
I'm sure you can Google and find some article that talks about the change of the name of the city. Attach that with an explanation.
Rahel is asking, what can we expect for the future of H-1B program in the perm processing next year? I think you said we'll defer that for next week.
Mm-hmm.
Thanks for asking, Rahel, but we will cover that next week. Bushra, I was with employer A for 10 years, who has my I-140 EB2 India with priority date July 2010. I joined employer B about 2 years ago. Employer B is asking me if it is possible for employer A to file AOS, and then employer B can transfer after 6 months by filing AC-21. Will it raise any fraud concerns with regards to intent? Any complexities that I have to watch?
Yes. As I said, you and the employer, when you're filing, because especially when you're downgrading, the employer's filing the I-140, you're filing the 485. You both are making an attestation under penalty of perjury that this is a bona fide offer of employment. So even though those are options that you can leverage down the road, right? Those are options that you have. You can't go into this thinking that this is what you're going to do, right? That's the difference between intent and not having the intent. And let me give you an example. You are able to defend yourself, and in the defense of your life, perhaps kill someone else, right? You are able to defend yourself and perhaps in the defense of your life, kill someone else against and there's other standards, but just generally speaking. But when you change that from I defended myself to, hey, I went into this wanting to kill them, that's intent. That is intent. So, and that is the difference between making something, because if you think about it, you know that AC-21 exists, that you are able, once the I-140 is approved and the 485 is pending for 180 days, you can change employers, right? You know that. You know that that's an option. But you can't file this I-140 and I-485 with your previous employer and saying in emails and saying in, signing forms or paying money in the, with the intent to change employers later. You have to be able to, at least now, the intent has to be now, to join the employer after the green card is approved. And why is that going to be a problem? if the Trump administration is back, believe me, and I have said this to people and they didn't listen to me, and you know, they were not only kicked out of the United States, but they are barred from reentry. If you file an I-140 with the previous employer, you better have documentation and evidence that you intend to join that employer after your green card is approved. If you change your mind later on, that's fine. But at the time of filing, you have to document that you have that intent. If you concoct a plan through email, through letters, I will pay you, all this stuff, my friend, they will find out. And you would have been deemed to have committed fraud. And so would your employer, so would your new employer, and I can't even tell you what the consequences of that are. So you have that option if you go through this in a smart, legal way. And people can change their mind, but don't go into this with this digital footprint everywhere of what your plan is.
All right. Next question is from Lakshmi, Kishore. Says, thanks Lakshmi for hosting the webinar, helping us. My question, I have an approved I-140 with my previous employer in EB2 category with priority date October 2015. I had changed employer recently and my current employer hasn't started GC process. Say, suppose the dates move rapidly in the coming months. Do I need to transfer my H-1B to my previous employer in order for them to file for my adjustment of status? If I have to go back, do they need file my H-1B transfer in parallel to the AOS and EB3?
Okay, so let me answer it in two issues. One issue is, do you have to be currently working for the employer that is supporting your I-140 485? No. But the second issue is ability to pay. If you are working for the employer that is filing your I-140 485 and they can demonstrate that they have been paying your salary, they will get a positive determination on ability to pay. So that is the benefit of going back to work for that employer, is that, you know, because you're not filing in October and you just changed employers not too long ago, it would be easier to demonstrate ability to pay.
All right. There are a couple of questions on, Telegram, links and recording links. And so I will have, our team member put on the chat. So you can go to the chat and you can copy that link and then you can go there and join Telegram, YouTube channels, subscription, newsletters, recordings. I think if you have joined today for the seminar, you probably will get the recording, the link, So in any case, please pay attention to the chat where I think this information will be posted. The next question is from an anonymous attendee. If after downgrading using amendment and using AC21, can we amend back to EB2? I think we answered this one. I think it does the 180, yeah.
And the answer is yes, and I did answer it.
Yeah. Another anonymous attendee, if there is a clerical error on date of joining for one employer by 15 days between I-9 perm and H-1 application, any issues or corrections we can make at this time filing 485 now?
So the I-9 documents aren't submitted for
15 days between I-9 perm and H-1 application.
You're gonna have to send me an email on that because I don't understand. I'm going to assume that you're asked that maybe they didn't complete the I-9 in a timely manner, but if you were on their payroll, the I-9 infraction should be addressed and the employer would have to do that. But if you were on payroll and it was just a paperwork violation, then that should not be a problem. All
right. So again, the email is info@shalalaw.com. You can also find that on our website, shalalaw.com. Another anonymous attendee, do you suggest waiting for the November visa bulletin as my priority date is EB2 2012 October. For current filing, what happens if I-140 is not approved 180 days after 485 receipt? I think it must be the same guy, same person. So, yeah,
You
sorry.
can, filing in the month of October, the benefit is you are in the adjustment, process, and getting the benefits of the adjustment. I don't know what November is going to look like. Now, the visa bulletin did say that they would advance rapidly, but they don't even know because they don't know how many people are filing this month and how many dependents they are with those filings. So it depends on what your risk tolerance is. That's pretty much it. And whether you want to have the benefit of having, doing a downgrade and filing a 485 at this time and then maybe amending back, or just waiting and seeing and throwing the dice and see what happens in the month of November.
All right, I think there's a twist in the question, similar question from earlier. My birth certificate has a state name from India missing an alphabet in the spelling. Is that an issue?
No, I would just say that there's a typo and they may not even notice. So I would submit it the way it is if it's just one letter. And if they should raise the question, you can just respond that it was a typo because all the other information is correct.
All right, here's the next question from Anonymous, and I think it's a little longer, so I'll try to be slow. And H-1B extension approved and still valid until January 2021. H-4 extensions for dependents are still pending because of biometrics. If I transfer my H-1B visa to new employer and apply again H-4 extension to my dependents before my current H-1 expires, my dependents will get I-94 or not on new H-4 approval extension. If the current,
they will. What you would do is when you're filing for the new employer, you would just include a copy of the pending I-539. And the other thing is, if you are changing employers and you're not filing for, that's what I would do. I would file the change of employer and then include the receipts for the I-539s.
So his follow-up question is the same. If the current employer withdraws my H-1B petition after joining new employer in H-1B receipt notice, what will happen to my H-1 and H-4 extensions, I-94? We will get the I-94 or not?
Well, you said your H-1B extension was approved and the I-539s are pending. So if your new employer files for amending your employment and an extension at the same time, because you can do both, then the previous approval notice is valid and you're now amending. So even if he withdraws it, that's still valid. Now, your I-539s, because you're filing them again with the receipt notice, so everything should be fine. I don't understand why there's a question or issue.
Well, I suggest this gentleman or a lady, whoever asked the question, if you're not fully satisfied with the answer, maybe you should send an email to info@chala.law and then, send more information or clarify what Lakshmi just was curious about, and I'm sure she'll answer. The next question is from Seema. My priority date is EB2 2015. My employer is not willing to downgrade or amend to EB3. They said there is a possibility of being rejected, and I may then will have to leave the country.
No.
I am with the same employer. Please advise.
No, and no. No for the I-140 does not impact your H-1B at all, even if it's denied. You can always refile, even if you're dependent on the 3 years extension. And number two, the amendment is in the USCIS policy manual. They say very clearly you can do this. So if you want us to talk to your employer, I'd be happy to set up a time to speak to them. We've been speaking to several employers that are worried, and especially if you're currently working for that employer, you're getting paid. by that employer. So the risk is actually, there is no risk. So email us at info@chalalaw.com and see if your employer is willing to have a conversation. Now, I'm going to warn you that there may be some employers are reluctant to do this because they know that after the I-140 is approved and the 485 is pending for 180 days, you can court. But if your employer is not willing to do this, maybe you want to do that anyway. So I think there are ways in which you can convince them that this is a good thing to do for employee retainment because you're making employee happy. And the EB2 is going to be, the priority date is going to happen at some point, and at some point you'll have that ability. But there is absolutely no jeopardy to your current H-1B, and you will not have to depart the United States. And when you amend, it is in the USCIS current Ken Cuccinelli policy manual. So there is no problem with that.
All right. Madhu Rao is asking, what is best? I have I-140 approved EB3 December 27. I would like to port my priority date with new employer. Which one is best option? Going to EB3 or EB2 with new employer? Which one is best to port my previous 140 based on in current priority dates?
Yeah, so he's 2007.
Yeah.
Yeah, so 2007.
December 2007.
Yeah, so use EB2.
Okay. Then Lakshmi Hitali just wants to thank you for solving her doubts. Gopal is asking, this is about applying for AOS using October VB date. My employer is filing for 140 EB3 AOS EOD. My question is, if there is a job loss due to layoff and employer doesn't cancel the 140, what happens to the pending 140 and AOS? Can I still join a new employer using pending EAD after 180 days of filing?
The I-140's got to be approved, and the adjustment status has to be pending for 180 days before you can port.
Okay. I just wanted to, it's about 1:40 close to, so we will be here till 2 o'clock. So I just wanted to make sure that, if your questions are not answered, please, we will try to answer and send it to you, the link that, on our website or, so you will know. But for some reason, if your questions are not answered, please send an email to info@chalalaw, and we're glad to answer it. Pushpak is following up a question regarding I-485J application. What do you mean by applying for age out?
Did he say J?
Yeah, regarding I-485J application, what do you mean by applying for age out? It wasn't clear what you meant by it.
No, okay, so there are two things you're mixing up. The J is if you file an I-140 485 concurrent application, the J is not mandatory per the I-140 instructions. So they may still ask for it later, but it's not mandatory, which means it won't get rejected. So if you don't have the J, and the J is usually used to talk about portability, change of employers, things like that. So the J. The age out is related to children who are going to turn 21. The dates of filing, which are the dates that are being used in October, do not lock in the date per se for children who are going to age out. What I said was the I-485 will not lock in the date, but instead of amending, if you are doing a downgrade, instead of amending your I-140, if you file a new I-140, the period of time that I-140 is pending will, you can benefit from, your children can benefit from the CSPA during that pending time period.
All right. And next question from an anonymous person. If the sponsored employer withdraw the 485 petition after 180 days and I-140 EB3 downgrade is still pending, what will happen to the 485 application in H-1B status? We start using the benefits of EAD and switch to a different employer.
Say it again, please.
If the sponsored employer withdraw the I-485 petition after 180 days, and I-480 EB3 downgrade is still pending. What will happen to the 485 application and H-1B status if we start using the benefits of EAD and switch to different employer by submitting the supplement J form from the new employer?
Right, your permit, if it's I-140 is approved and the 485 is pending for 180 days, you can change employers. You can change employers to same or similar employment. You can be your own employer for same or similar employment. And you would just file the supplement J. So no impact, but the I-140 must be approved. The adjustment must be pending for 180 days.
All right, I'm seeing some of questions about, spelling mistake or kind of more like a transition in history, right? Bombay to Mumbai, Andhra Pradesh, Telangana. So I think Lakshmi Chala earlier said, what did it occur first? Birth certificate says Bombay, but then the new rule is Mumbai, right? So you find an article and say why it was changed from Bombay to Mumbai. Same thing, Andhra Pradesh, now it is Telangana, same thing. So whichever event occurred first in the timeline in your lifetime, that should be the starting point. And you explain, further, what you call errors associated with that.
The discrepancy.
Yeah, discrepancy or errors, for lack of a better word. Here is a person, next one. He says, I'm a teacher. They are saying they may question EB2. Can I take the risk? Thank you, Ms. Lakshmi, for willing to help. I will email you. You rock.
Oh, great. Thank you. No, I don't think, because when they say they're questioned the EB2, when you downgrade, the minimum requirement for the job has got to be a bachelor's degree or higher. Can they question? I mean, that means there is no problem if the job requirement is more. It just can't be less. It's not the ceiling, it's the floor. So it doesn't mean that the bachelor's degree, you can't exceed a bachelor's degree. It just at minimum should be a bachelor's degree. But email me. We'd be happy to help your employer straighten that out.
All right. The next question is about is from another anonymous. Can we get the copy of the I-140 withdrawn reason from USCIS or FOIA? Can we get the copy of PERM application approval notice from USCIS or FOIA or DOL?
No, you can get, if you're, because presumably you have a relationship with the, I'm assuming you're trying to do a downgrade and you want a copy of the PERM to be submitted with your new, either amended petition or new I-140. So if you've got a relationship with that employer, the employer has the ability to log on to the DOL website and print out a copy of the PERM.
Okay, Sandeep Kaur seems to be waiting patiently. She took her hand off and now she's got a question. My EA is still pending at Mumbai Consulate. Is it advisable to wait in India till October 17th on EA and stamp, or better to fly to third country this weekend on the 11th to get stamped quickly? If I'm reaching in the US by the week of October 24th.
Right. What I would tell you is, in any event, there's always a risk, right? I mean, anytime you're processing. What we can do is just tell you what the experiences have been. And then, you have to make that assessment of the risk based on that. You don't know, how Mumbai, if they're going to ask questions, if there's going to be issues. They are the friendlier of the consulates. They're much better than Delhi. You have that as a question mark if factor. You do know that you can get an appointment in Mexico. Hopefully you have secured the appointment. If that is the case, there is, I know I've gone over your case and asked all the questions about processing with the contact in Mexico. I have not used them before, so they only contacted me right around the same time I started talking to you, so I wanted to connect you both. But from what he says, and from what I've always heard from Mexico, consular processing, is it's easier than it is in Canada. So I think that, with the type of work you're doing and the evidence that you can submit to show, and we talked about that evidence already, that would be compelling. I think that you have to get into the country in order to file the adjustment. And I still don't know if your previous employer intends on filing an amended petition.
Our follow-up question was, if I am reaching in US by week of October 24th, will 1 week be enough to file for I-485, especially when 140 is with my previous employer, who will file for adjustment of status and wants to transfer visa also?
Right, as long as he's willing to do that concurrently. So he can't wait for the H-1B transfer to get approved, or for you to get a receipt notice before he is willing to file for your I-140-45. It's got to be, because you've got 6 days. The 24th is, and you can get started with that process right now. He can, the 24th is a Saturday. And so you've only got and Friday is the 30th. So I would say Wednesday is the last date of filing. You should be ready to go by Tuesday with whatever you have.
All right. I see quite a few people are, are on the call, but they have not asked a question. At least I have not seen their name. So I'm going to give a chance to Ashok Jagarlamufi. If you can unmute yourself and ask your question. Or maybe I have to unmute, or Lakshmi have to unmute.
You have?
Ashok Jagarlamoody, I think, must be in Richmond, Virginia. I must seem to have met him before. But it comes up about Mufi. Ashok Jagar.
Yeah. Okay, I've unmuted him. He may not have a question or.
Yeah. Ashok, are you there?
He hasn't unmuted
No,
himself.
I think
Why don't you ask people who want to talk, who haven't had a chance to ask a question, if they want to raise their hand?
There's Seshu has raised a hand. Seshu, can you unmute yourself?
Seshu?
Seshu.
E-S-H-U?
S-E-S-H-U. Seshu.
I have to, okay, there we go. I allowed him to talk.
Okay, Seshu.
I've allowed you. You got to unmute yourself.
Yes.
Yeah.
Do you hear me?
Yes.
Yeah. Thanks for taking my call. I already asked my question, but what my employee is saying, it's not a good. Like for example, I'm getting filing an adjustment through my wife on EB2. At the same time, because my priority date are not falling under EB2, I am planning to downgrade to EB3 through my employer, not through my, but my employer is suggesting you cannot have multiple I-144. It unnecessarily confuses the USCIS. So they are suggesting don't downgrade now.
Yeah, I mean, it doesn't confuse the USCIS. Whose is the older priority date, yours or your wife's?
The current on EB2, the current filing date is I'm filing through my wife. The downgrade I'm talking about is through me as a primary.
Okay.
In my wife's things, I'm a derivative.
Mm-hmm.
So my employer, because it's a better, anyhow she's filing on EB2. I thought if I'm filing on EB3, it's better because even if the EB3 date files, I can leverage my.
Yeah, and there's no confusion. People do it all the time, so there shouldn't be a problem. If your employer would like to talk to an attorney to make sure that there's no issue, I'd be happy to speak to him.
All right.
Okay, yeah.
Sorry. Can I go to the next person? Yeah, Ashok has raised. Ashok, can you unmute him?
Okay, you said Ashok?
Ashok Jagarlamoody. I thought he
Okay.
raised his hand, but maybe not.
No.
But let's go to Hardik
Oh, he did.
Patel.
He did.
Okay.
Hi, Ashok. You got. There we
Hey
go.
Lakshmi, how are you?
Good.
I think I do have one query that I mean, a lot of people are applying for this 485. I mean, if they're applying for EAD and if they get an EAD, when they're applying for when they're processing the 485, if the 485 got rejected, like what are the? I mean, I see that couple of people there is a chance that DOI or like any tax filing issues or any other like an employer fraud. If some reason, if any of the employer did a fraud, there is a chance that 485 can reject. What are the
Right,
main
but
problems when you're applying for 485 if
no,
you're
because
still in EAD?
you can get an EAD, but as long as you don't use the EAD, your H-1B is valid. You cannot use the EAD to work for an employer other than your H-1B, because then your H-1B becomes nullified. It becomes invalid. So you want to make sure that your H-1B is preserved, and if anything should happen to the 485, your status is not impacted.
Do you? I think I see your recommendation, but you are waiting until you get the date is current. You won't wait on H1B. But a lot of people are planning to move it to EAD, not on H1. So if they're continuing on EAD for next 10 years, like people who are in 2015 or 2014,
until your I-140 gets adjudicated, I would not recommend anyone starting work on their EAD.
oh, you don't? Okay.
No, I mean, that's a risk. That's actually being too greedy, because probably in the next, I don't know, so many months, the I-140 may be adjudicated. You've been waiting for years. Why do you, just to get a jump on a few months, would you want to jeopardize your immigration process? Once the I-140 is approved, and you've got the 45 would have been pending for 180 days, then you can take that chance. But it is very risky to do that right now. Tell your friends to join us on Telegram, because I'm going to post something about that. And I wouldn't do it if I were in your shoes. And I've gone through the immigration process. I wouldn't let my family members do it. It's just wait for the I-140 to get approved.
Yeah, but even though I-140 approved and you applied for EAD, you received EAD, still my priority date is supposed to take an example that 2014. At that point of time, do you want to stay on H1 or you want to convert it?
No, once you're okay, first they'll issue the EAD, but as long as you don't use it for an employer other than your current employer, there's no harm. Okay. Second, once the I-140 is approved and the 485 is pending for 180 days, when you're allowed to file the supplement J, the majority of the risk is already over. I-140 is approved, 485 is pending 180 days. You're working for same or similar employment. The risk has been diminished to this. Then you can start working on your EAD. There's no problem.
Okay, then when you're working on the EAD, when the dates are current, there's no chance that, rejection, I see that some people working on EAD for 10 years. At the time of filing, their 485 got rejected. They're out of status. Either they cannot go back to H1 and they need to move out of the country. But it's really very, very rare cases. I see some people because of some tax filing issues or some company issues.
See,
they're
right. So that's why I'm telling you to wait for the I-140. The biggest risk is the I-140, right? Because the I-140, they're looking at ability to pay. They're looking at the employer's ability to pay. They're looking at your background. They're looking at eligibility. These are the main things. What are they looking at in the adjustment? In the adjustment, they want to make sure you haven't, it's about you. The I-140 is about your employment. The adjustment is about you. Criminal record, medical history, things like that. So as long as you haven't committed any crime, and your I-140, for the vast majority of people, there's no issue. It is the I-45, it's the I-140 that has the greater risk. The best case scenario is to keep the H-1 alive, do transfers, do whatever during this time frame. If the new regulations come into play, we don't know if President Trump is reelected and it becomes more strict, then yeah, you can use the EAD, but only after I-140 is approved.
Ashok, I suggest if you're not satisfied, please send an email to
I mean, if you,
info.
right, like if you want more details, you can email us at cellolaw.com. And this is something I'm going to post on Telegram, and Kara has put the link on there. So please join and have your friends, whoever is planning on getting on an EAD, immediately to join. So I can outline what the risks are.
Yeah, so I'm going to take
Thank you, both of you.
I'll take a last question from Hardik Patel, and everybody else, I apologize. Some of you have raised your hands, but I see some of you who raised your hands also asked your question, and your questions were answered. So if it was a follow-up question, please do send info@chalalaw.com. And your attorney needs a break, as you know, 2 hours she's been talking, so she needs to eat and drink something so that she can continue to give you advice on Telegram and email and all. Tomorrow again, webinar and Zoom and all that. So please spare her for a minute. Let's unmute Hardik Patel. Mr. Patel, go ahead.
Hello, ma'am. How are you?
Hi, how are you?
I'm good, thanks. Okay, I have a quick question. We understand all this movement is because of getting a new pool of visa, which is around like 260,000 approximately. So out of this, can you please predict or help us understand how many of these can go to the EB1 or EB2 or EB3? Any predetermined plan?
No. Anybody that can tell you they can predict that is absolutely telling you a lie, because it's predicated on a number of things. Number one, it's predicated on how many family members there are per petition. People can guess, estimate, we're not sure. But there are a lot of people that are telling me, oh, I'm not going to put my children on there. I don't want to take the risk. So we can't predict what that is. Number two, I am predicting that there's going to be a lot of, because like I said, I went through and I looked at the denials. There's going to be a lot of these that are going to be rejected because the attorney didn't fill out the form properly. So you're going to have those rejections that won't count against it. So it's really hard to predict what's going to happen in November.
Okay,
I've been doing this for over 25 years, and I've been at this, this has happened previously when I've been practicing. So I do know that there is a lot of uncertainty in trying to make that prediction.
Right. So what I was trying to make a point, so if you look at the visa bulletin, there is something specified that every yearly, whatever the per country quota is there, the 28.7% goes to EB1, similarly 28 something goes to the EB2 and EB3. So is there a chance like a similar calculation might be followed for this one? Any prediction?
No, and the reason is this, I'll tell you why. Because of the presidential proclamation, there has been a substantial, and the pandemic, a substantial reduction in the number of petitions that I-45s that can be filed, right? So that has never happened before. In the previous time periods, the two time periods where the numbers became current automatically, number one, it was because of DOS made a miscalculation during the Obama administration. And there was one time in the previous Bush administration where it became current because they just printed it incorrectly, but because it was the Bush administration supported immigration, they were willing to allow processing for that time. It was in July, I can't even remember the year, I think it was several years ago, but those are the only times it's ever happened. What's happening now is it's going to be a record number of people who are going to be filing to downgrade. What we can say is EB3 is going to advance. I mean, EB3 is going to, may retrogress, and EB2 may advance. That's a prediction we can make. But how it's going to be allocated, it's tough.
Okay, perfect. Thank you so much. Appreciate it.
You're welcome.
Thank you, Mr. Patel, and thank you, everybody.
Thank you so much.
All right, you want to do closing?
Yes, I was just going to say that if you all would like, and I think we'll post it on Telegram as well, that if there is a special another session that you would want me to conduct, we can do one just with Q&A. We can download the questions, so we will download them, and if there's a common questions that we see, we'll try to answer them and post them up. But join the Telegram group, because it's very difficult for me to communicate on a number of different platforms, but I'm communicating with this Telegram group directly, and so is Kara. So we're spending a great deal of time trying to get them resources, answer questions, and things like that. Thank you again for joining us. If your employer has any questions, I mean, this is a real great opportunity, and I think everyone should get a chance to leverage it. So email us at info@cellolaw.com if we can do anything. And we'll see you next Wednesday if we don't see you earlier.
Have a good day, good week ahead, everybody.
Cello Law signing out. Thank you.